and welcome all to today's Berkeley Judicial Institute program, Justice Abandoned. My colleague Justin will put some information both about Berkeley Judicial Institute and about our spectacular faculty in the chat. Long story short, now that we have you here, we'd love to have you back. Check out our website, watch past programs, read interesting things, follow us on social media. But that's not why you're here. You're here to hear these two spectacular people. We have a lot to cover today, so forgive, with his indulgence, my brief introduction of Judge Alldredge. Judge Brett Alldredge is retired from the California Superior Court. I've said it wrong in the past. Superior Court, right, Judge Alldredge? And his vast work in the criminal area includes responsibility for pretrial, mental health diversion, and drug courts. He is such an enthusiastic booster and supporter of Berkeley Judicial Institute, and we are so grateful for his work. That work includes being a talent scout, and he recommended someone who he feels has really changed who he is as a judge and how he does his judging work, someone whose insight is so profound for him. So I will turn things over to Judge Alldredge to introduce that muse, Professor Rachel Barkow, and talk about her provocative work that brings us all here today. Judge Alldredge, thank you, and thank you, Professor. Where will we start today?
Thank you so much, Denise, and good afternoon to you all. As a quick programming note, I'm sure many of you, after listening to Professor Barkow, are going to have questions. And I believe it's going to work best at the end. We'll leave time for those questions. If you would use the chat feature on the bottom of the Zoom programming platform, and Denise will collect those. And then when we have some time at the end, she'll be able to pose those to our esteemed guest, or if you would like to ask your questions directly, raise your hand using the hand feature, and Denise will monitor that as well. Once again, welcome this afternoon. As a fan of BJI's superb programming, today we're in for a real treat. Whether you already know or know of Professor Rachel Barkow, or whether this will be your introduction to an absolutely true star in legal academia. She is a distinguished professor at NYU Law with an accomplished CV to match, but she is much, much more than that. I believe she is singular. Quite simply, the breadth and quality of her experience is such that it almost tricks you into predicting how that experience would inform her perspective on our criminal justice system. And quite frankly, you'd likely be wrong. She was a member of the Federal Sentencing Commission for a number of years, yes, yet writes clear-eyed how our federal sentencing scheme has helped lead to mass incarceration. She clerked for Supreme Court Justice Antonin Scalia, but those who would use that priceless experience to predict her perspective or her point of view on how the Supreme Court, including the Scalia term, has affected our criminal justice system would also likely be in error. Her scholarship focuses on criminal, constitutional, and procedural law, yet it is her foundation in administrative law that enables her to begin a sentence by ticking off data, accurate data, what we used to call facts, yet end it with the real name and story of a human being who is much more than a statistic. And that is why her insight and perspectives are welcomed as easily by groups like the Federalist Society as it is by the ACLU. Her recently published book is Justice Abandoned: How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration. With that provocative title, Professor Barkow, welcome to the Berkeley Judicial Institute.
Oh, thank you so much. It's a pleasure to be here.
You have written what I think is an exceptional book, one that at first glance may appear familiar to judges and lawyers who are used to reading case analysis, but each of the 6 carefully chosen chapters goes much further and is written in a way to easily be understood and compelling for anyone interested in how we got here. You write, if the court was committed to protecting constitutional rights and followed its standard methods of interpretation, none of these cases would have been decided as they were, and punishment in America would look very different than it does today. In fact, what these cases have in common is an unquestioning deference to whatever the government argued was necessary for the efficient pursuit of public safety. Why the focus on the Supreme Court as opposed to the policy choices that you revealed in your first book, Prisoners of Politics?
Yeah, no, it's a good question. And that's kind of how I got there, was sort of because of the first book. So, I generally write about the political dynamics that lead us to policies that it turns out don't really work for public safety, or they're not the best approach. They're not the most cost effective. And so it's always a puzzle to me how we end up pursuing things that are just not very good at what they're trying to do. And my first book, explored all that, explained some dysfunctions that lead us to kind of keep doing the same thing. And when I got to the end of that book, I thought I should have some solutions, right? I should have something to say about how we could get ourselves out of this. And the last chapter, I had mentioned, well, one strategy is litigation, because there are some constitutional protections that should put the brakes on some of these dynamics. And I had suggested, maybe one of the reasons why those haven't really worked is because of the kinds of people who get appointed to the bench. Maybe we just have too many former prosecutors and government lawyers. And so, it's just kind of would be good to have professional diversity to change the dynamic a little bit. And as I thought more about it after writing the book, I just kept coming back to it in my head. Like, it is crazy that there are all these constitutional provisions that were supposed to stop this very thing from happening. And yet we didn't get that. And then I was thinking about, well, it's actually the Supreme Court. It's really Supreme Court cases. And, I had a couple in mind already that have always bothered me, but I started thinking more about, like, how many of these are there where the court just gave in to some claim of public safety and didn't really do what we usually expect of the court, which is to be, very careful, look at the text, look at the history, make sure that it's consistent with precedent. And when I started thinking about that and doing that, I realized, that there's actually this critical mass of cases, and they cover the range that really does pave the way for mass incarceration. And I thought it was important to document the Supreme Court's role and let people know that it's not purely politics, although I think that's the main driver. That's what gets us the policies. But in our, 3-branch system, there is a branch that should be checking some of that dysfunctional political process if it's inconsistent with the Constitution. And so my hope with this book was to show people that the court didn't step up to the plate that the way it should have in stopping it. And, hopefully optimistically, making people realize that's one place to go to try to seek change. It's possible to overrule cases. We have a court that's very interested in overruling things that they believe have been wrongly decided from the outset. And so my hope is that these cases can join the group of cases that people point to and say, these were wrongly decided from the outset. They should be either extremely narrowed and cabined, or maybe overruled outright. And put this court to the test of whether it's going to be consistent in terms of how it thinks about overruling precedent, not just necessarily for what we might think of as traditionally conservative outcomes, but, any outcome that would be one where the initial decision was egregiously wrong and inconsistent with the Constitution.
I believe that you said at least a couple of times that you could have chosen other cases to highlight the point you were trying to make. But these 6 were chosen because they represent a connection. Do you believe that that was done over 25 years to intentionally build a body of consistent jurisprudence? Or, like so many things in life, are they only connected by us now looking backwards at what otherwise would have been 6 standalone decisions?
Yeah, I don't think it was intentional. I don't think it was, that the justices sat down and thought, how could we become the most carceral nation on earth? What does the government need for us to help them out? I don't think it was anything like that. I do think there's a common dynamic in these cases, which is that the court is very deferential to the government and to government claims that public safety or the efficient operation of the courts and the system make it a necessity to go along with some claim that the government is making. And I think basically the post-Nixon Supreme Court was very receptive to that notion and those ideas. And so all the cases come from that point onward. They're a Nixon and onward Supreme Court. And those claims are ones that get a very receptive audience from the justices so that you can get a majority, often a very large majority of justices to go along with it. And I think, that's the common thread, if there's a common thread here, but I don't think it was specifically outcome oriented. I think it was more this idea of, the government is asking for this, the government is claiming it's necessary for public safety, and a unwillingness to really take a objective look at whether or not that's actually true. And, I think there's echoes today. I really do. At first when I wrote the book, I didn't know what was going to happen this year. I didn't know what kind of environment we would be living in. And initially I thought, wow, this is ill-timed because there's so many bigger things going on. There's just so many bigger questions about the strength of our government and democracy. But actually, in the last few weeks, I've realized, no, this one is pretty on point, because I'm seeing the same kinds of arguments by the government. The same kind of idea. We can't obey due process, strictly speaking. It's too much. The procedures would be too expensive. It would be too time consuming. There's a huge risk to national security and public safety. Those are the kinds of arguments you see in these cases. They're the exact same kinds of things. And it's the court, really wanting to bend over backward to make sure that the government gets what it's asking for, because the claim is, if we don't, everyone's at risk, and the whole way we think about our security could be at risk. And I think those kinds of arguments have played with the court in a way that it's been hard, I think, for the justices to feel comfortable second guessing claims like that. And I get it, I get it as a matter of human nature and how you're going to think about, do you want to be the one when the government says this is necessary for safety? But I hope in these cases to point out, not only were they wrongly decided if you use certain metrics of constitutional interpretation, but, kind of hearkening back to the first book that I wrote, they actually were wrong on the public safety score too. The claim was you needed to do this for public safety, but it turns out in these contexts, most of these cases backfire. They don't make us any safer. Sometimes they make us less safe. So, it's been tragedy, really, that we've traded away these protections and we didn't really get the safety that we were promised in return.
Borrowing somewhat from a famous Russian author, I believe that all great judicial decisions are alike, but all unhappy cases are unhappy in their own way. And when you and I were first introduced to each other, I mentioned how much of my last several years in judging was dedicated to pretrial reform, especially here in California. And you told me then that I would be especially interested and appreciate what case you chose to lead off in your book. So in inviting you to explain why United States versus Salerno is so consequently related to mass incarceration, I have to make a small admission, and that is in easily over 100 times in making a record why I was ordering the pretrial release of an arrestee, I quote the opening line of the concluding paragraph of Justice Rehnquist's majority opinion. In our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. But as you so meticulously reveal in the book, I think I may have missed the memo. Could you tell us all the extraordinary story of Salerno's unbelievable history and its true consequences?
Yeah, and I think that Salerno is probably the case that for anyone thinking about what does the book offer to us today and thinking about the current climate of requests for, immigration detention or removal without certain procedures, I think the echoes with Salerno are the ones that are going to be the strongest for thinking about how it fits in with our current landscape. So when Salerno, before we get to Salerno, the case itself, I'm going to take you back to 1968, because that is the year that Richard Nixon wins the presidency. And, it's a tumultuous year. For anybody who loves studying history and reading about history, I highly, highly recommend anything you can get your hands on 1968, because it's a bonkers year in American history. And in that campaign, President Nixon is running on a law and order platform. And he is basically promising that he is going to bring an end to the unrest that the public is seeing. And, and it's legitimate unrest because homicide rates are high. So that's a pretty reliable index crime. It really is true that we have higher crime rates. There's a lot of protests, a lot of civil unrest. And he wins on that platform and he gets elected. But almost as soon as he gets elected, it's kind of tough for any president to control crime in America. Like that's not really a presidential kind of thing that you can easily adjust. So he tries to think about what could I do to sort of signal I'm actually doing something about crime. And he and his team come up with the idea that they're going to craft a new pretrial detention framework for the District of Columbia. And he gets one of the members of his administration to draft a bill, along with other people. But one of the lead drafters of this legislation for the District of Columbia is Bill Rehnquist, who will later become, the Chief Justice of the Supreme Court. But at this point, he's working in the Nixon administration and he's helping to draft this law. And they're going to create the ability to detain somebody after they've been arrested. On the idea that the person is dangerous. So this was a departure from 200 years of how we had approached pretrial detention before that, because the norm before this point was that, yes, you could detain people pre-trial, but you were doing it because the thought was they might be a flight risk or they might tamper with evidence or harm a witness, and you just needed to stop them from making it so that a trial couldn't happen. So the idea was you just needed detention only to preserve having a trial happen, but that was it. It wasn't for any other purpose. If you thought someone was dangerous, you had to go through civil commitment. You had to go through the process by clear and convincing evidence to show somebody, was a danger to themselves or others. It was much more onerous. But when you're in the criminal justice process, the idea is you're presumed innocent. And so you're free pending your trial and your conviction, at which point then you could be detained. But unless there was some risk of flight or witness tampering or whatnot, you would be released. And the idea that the Nixon team has is, well, let's get rid of that. Like let's expand that. Let's allow people to be detained on the basis of dangerousness that's triggered by their arrest for criminal activity. And they know they're doing something different, right? They know that this is a departure from settled understandings. So they, one thing that happens is the Attorney General of the United States, John Mitchell, who some of you will know, will later find himself in trouble for his relationship with various Watergate issues, and so he's gonna himself be convicted. But at this point, he's the Attorney General, and he writes a law review article, which is kind of hard to imagine today that the Attorney General would, would say, we're going to have this new plan. It'd be a little bit like, I think today, if the Attorney General decided to write a law review article on like birthright citizenship. But that's what they have. John Mitchell writes this article defending the idea of detention on the basis of dangerousness after arrest. And it's a pretty terrible law review article. If you're curious, I highly recommend checking it out, because I think you will see why I'm going to say this is not a great piece of scholarship. And after he writes it, there's a response that's written by Larry Tribe, the great constitutional law scholar at Harvard, that decimates it, explains why it's wrong in a million ways and it's inconsistent with our constitutional structure. So at the time that Mitchell writes it and that they're coming up with this idea, they know that they're testing the boundaries of what we had understood the Constitution to require. So because they know that, they're not making broad proclamations of what this will do. In fact, just the opposite. They're saying this is going to be super narrow. It will be like maybe 10% of all cases, the worst of the worst, that people we can't leave on the streets. And again, I think like some echoes today when you hear thought bubbles from the administration saying maybe we'll detain American citizens in El Salvador. And, the claim is, well, it'll be the worst of the worst, the tiny percentage. So that's the argument that's put forth. And when they write the DC law, it is narrowly done, precisely because I think they know they're testing the boundaries. And, that law would require you to show, the substantial likelihood you would be convicted. You can't be detained for more than 60 days. So it's done in a narrow way. And it it ultimately gets through the lower courts. It never makes its way to the Supreme Court. It survives lower court review. And after it survives lower court review, states around the country think this is a good idea, right? We have high crime. This DC got away with this. Maybe we should pass laws like this. And so that notion of allowing pretrial detention for dangerousness after arrest really takes hold. And it takes hold at the federal level too. And so ultimately Congress writes the federal bail reform law. By the time Congress gets around to doing this in the bail reform law in 1984, people kind of gotten used to pretrial detention. It's because it had spread the way that it had. That law doesn't have any of the safeguards the DC law had. So there's no limit to how long you can be detained. It's not that you have to show the substantial likelihood you were actually the government was going to win and prove its case. And in fact, far from, it being kind of narrow, although I think some of the senators thought it was going to be narrow, there's various presumptions written into the federal bail law that you're presumed dangerous if you commit or you're arrested for committing certain crimes, including drug crimes. So if you're charged with any drug crime that has a statutory maximum of at least 10 years, which is almost every federal drug law, you're presumed dangerous. So that's the law that gets before the Supreme Court in Salerno. So that's the first time the Supreme Court is going to decide, hey, can you detain somebody on the basis of dangerousness after an arrest? And then the facts of the case that go to the court are, when I was researching the briefs and the facts before it, I almost couldn't believe what I was reading, because the case that the government decided to bring, and I don't blame them, this is pretty amazing if you're a litigator, it's Tony Salerno, otherwise known as Fat Tony, is the boss of the Genovese crime family. So, he's the head of one of the 5, large mafia families controlling organized crime in America. And he is being detained pre-trial. And the government's argument is, yeah, the head of a major crime family is a danger. You can order hits. We should have him detained pretrial. It's him and one of his top lieutenants. Vincent Fish is his nickname, Cafaro. And the claim is they need to be detained pretrial because they're dangerous. What the government doesn't tell the Supreme Court is after cert was granted, after the petition was filed and cert was granted, Fat Tony had been convicted in another case. He had been tried, convicted, and sentenced to 100 years. And, you probably all know this, when you have been sentenced, you start serving your sentence pending your appeal if the argument is you would be a danger to be released otherwise. So the idea would be he is starting to serve his 100-year sentence, so he's not in pretrial detention anymore. So the case should have been moot as to him, except that the government convinced the judge not to start his sentence yet, which is, again, there's the inconsistency, because if he was supposed to be a danger, the sentence should have kicked in. But they created a record that made it seem like he was still in pretrial detention. And then his lieutenant, Fish, it's even worse, because after the petition was filed, but before cert was even granted, the government never tells the Supreme Court that they had actually signed Fish up as a cooperator. So he had been released from pretrial detention. He was cooperating with the government. So he's out and about, he is out and about getting information on other people in the crime family. And the court has never told any of this. So the case itself really came to the court under these really, the suspicious is the wrong words, but just really distasteful circumstances, which there's an opinion in dissent where Justice Stevens is like, this is, a little odd, but the court allows it to continue and decides the case anyways, because I think the Supreme Court and its opinion writer, who is none other than Bill Rehnquist, the person who wrote the DC law, which is basically the origin of this entire regime, he writes the opinion. And the opinion he ends up writing just kind of does away with 200 years of history on pretrial detention in a very brisk way. He doesn't even give 2 pages to the 8th Amendment and how you interpret the bail clause. And for the notion that there's a presumption of innocence, he basically says, oh, that's a burden of proof thing. It doesn't apply to detention. Detention is just a regulatory measure. It's not punishment. And so we just have to make sure there's, a rational basis for imposing it. And the argument that he relies on, that the court relies on for this idea that it's a regulatory measure, is they rely on the Solicitor General's brief saying, yeah, the government is allowed to detain people in emergencies and for public safety, during wars and insurrections. And we've recognized when the government does that, it's not punishment, it's a regulatory matter. And the case that the Solicitor General cites to support this entire framework is Korematsu. That's the lead case in the SG's brief. So, the entire root of Salerno is based on Korematsu, which the Supreme Court is later going to disavow and say was a low point in our nation's history, allowing the internment of people of Japanese Americans who have Japanese descent, allowing them to be put into camps in America, is a black mark on our country's history, and the Supreme Court disavows it later, but it is the basis for Salerno. That is the case law on which all of this rests. And after Salerno is decided, and the line that you quote where the court says, there's still a presumption of liberty, this is narrow, and the government had claimed it was going to be narrow in the case. The reason I include it in the book, not only because it's inconsistent with the text of the Constitution and the Eighth Amendment and the presumption of innocence and this 200-year history, and it's this kind of novel departure, but it is really critical to mass incarceration because on any given day in America, it's about a quarter of the people who are locked up pre-trial. So it hovers right between like 450,000 and 500,000 people are locked up having not been convicted of anything. So they're about a quarter of our mass incarceration. And, most of them would not be there, but for this acceptance of the idea of dangerousness. And in Salerno itself, where they thought it was going to be really limited, maybe 10%, the reality is in the federal system, you're looking at like 70% of the defendants detained pre-trial. It's about 60 to 70% based on the studies. And, most of them it's triggered by that drug offense presumption. So the idea that they actually are dangerous is pretty specious because it's just this presumption. And not only are so many of them detained, where it's, well over half, but they're detained for really long periods of time. Whereas the court thought speedy trial would be a ceiling on it. As it turns out, the average in the federal system is 255 days. So it's about 8 months. And in some districts, it's over a year. And there's egregious cases out there, that I'm kind of shocked to read about some of the cases where cert was denied. There was one guy, he was held pre-trial for 3.5 years on a death row because that was the only space that they had. They ran out of space in their jail for pretrial detainees. So he was put with the other people awaiting death row. And he was on this death row for 3.5 years, in solitary. And some of the people on the row had been executed while he was waiting for his trial. And, he filed cert basically saying you couldn't possibly have meant this in Salerno, right? Like this, we seem a long way from that quote. And, cert denied, and basically cert denied across a whole range of cases, such that in America today, I think people just accept pretrial detention as this kind of normal thing that we've always had. Of course, you lock people up when they might be dangerous. But it really wasn't like that. And instead, it was part of this orchestrated idea to change the law, to change the constitutional understanding that ultimately gets accepted by the Supreme Court. And, here we are, 50 years later from the time in which that plan was kind of hatched. And, almost 40 years from the time the Supreme Court decided the case. And I think now when I mention the idea to people that, you really shouldn't detain people just because they've been arrested, I'm looked at like, well, that's crazy. Of course you do. But it really was the opposite before this kind of concerted effort was made to change the doctrine.
There's a lot to unpack there. I've already bragged on you a little bit about your ability to recall statistics and facts, and I don't want to put you on the spot, but you've alluded to it already. Prior to Salerno, and I'm sure these stats are in your book someplace, there's a certain number of people or a percentage that we were locking up either in the federal system or across the United States. 15 years later, do you have at least some estimate of those percentages or numbers that changed so significantly in that short a time?
Yeah, so from 1970 to 2015, it's a 433% increase. So, it's almost 4.5 times as many people, which suggests it's less than 100,000 total, when we're looking at 1970, significantly less, to balloon to where it gets to today. And the percentage, of the population that could be detained becomes this enormous chunk of people. So, I don't want to suggest that there weren't people who were detained before this was done, because I do think judges were using bail amounts, not just for making sure people didn't flee and not just for witness protection. I think there were some judges who were improperly setting bail based on dangerousness. I think that happened. I think it does happen today. I'm in New York, the kind of last bastion of let's only have detention on the basis of flight risk and witness tampering. And we have plenty of people detained pretrial because judges really do set the bail amounts taking dangerousness into account, even though they're not supposed to. So we did still have people, but nothing like what we have after it becomes accepted. It is a 433% increase. So it's enormous. And it just changes, I think, not only the absolute numbers, but I think it changes people's mindset. It becomes normalized. And I think if you go from the difference to thinking, I'm not really supposed to do this, but I'm going to do it in this case because I'm so nervous of this person's danger. That's a different mental outlook than I think what we've come to today, which is I think judges think if I don't detain somebody, I'm going to get criticized for it. I'm going to get criticized because it's not like the norm is people expect detention. And if I don't detain this person and they end up committing a crime and my local tabloid newspaper runs a story on it, I'm going to be pilloried. And, and there's empirical studies about judges and their detention rates as they get closer to election. This is all demonstrated as a real incentive that's out there. And I get it because the public now thinks this is completely normal and what should be expected. But, our Constitution is supposed to be made of stronger stuff than that. It's not just supposed to be things the public might think would be a good idea in the short term. It's supposed to be thinking about long-term protection of liberty. And, again, just to kind of go back to a point that I made at the outset, which is the really sad part about all this is it doesn't make us safer, because when you are detaining that many people pre-trial, we also have the studies that show we're making it more likely that they're going to commit crimes. Because, if you take somebody and you detain them even for a few days, that is the difference between them keeping their job and losing their job, keeping their apartment, losing their apartment, keeping their kids and losing their kids into foster care or other kind of arrangements, because it upends your life when you are detained. And it's, we have the studies that show that, people with otherwise similar records, types of crimes they're accused of, the person who is detained is way more likely to recidivate than the person who isn't because of this disruptive effect. So, it's just been a really tragic and sad outcome that traces its roots to this idea that we should have more detention for dangerousness, even though it shouldn't be constitutionally permissible. And it's expanded beyond all recognition of what the original arguments were about who would be affected by it.
You've already touched on this, but there's an extremely painful part of the history that you were able to research and tell. And as we speak today, it feels eerily prescient. You already indicated that Justice Rehnquist's opinion drew heavily on the Solicitor General's filed brief that starts by noting the president can deport, quote, dangerous aliens, end quote, during times of war, including the detention and relocation of American citizens, citing Korematsu. You write, quote, the Korematsu decision has been excoriated as one of the 2 or 3 worst moments in American constitutional history. It's hard to imagine a more offensive citation in support of pretrial detention than Korematsu, and its acceptance in internment counts to hold people of Japanese descent during World War II. Did you have some crystal ball or something when you wrote that line?
I did not. I did not. And I haven't really been able to stop thinking about it in the last few weeks, because it's just eerie to see how these arguments play out in real time and see how these kinds of things get going. There's a fear that is based on a concern with public safety and crime, that if you get the public that's afraid of something, and then you have a government that that knows about that fear is either capitalizing upon it or shares it or however you want to characterize it. But then, makes the claim that you've got to allow us, the government, to keep you safe by shifting the constitutional ground that you're used to. And I think the really eerie parallel for me is this idea that when the idea has been floated by the current administration, when reporters have asked, the response by President Trump was, well, this would be the worst of the worst, the rapists and the murderers and the people who snatched the purse of the 89-year-old woman. And for stuff like that, I will say, researching this book, there have been a lot of contexts where there are these kind of the worst of the worst arguments that are made, and that line never holds. One thing I can tell you from my research on criminal law for a very long time now, and looking through an awful lot of different contexts, is we never hold the worst of the worst line. Like that gets obliterated almost immediately. And as soon as you create exceptions or allow a given practice to occur, it expands rapidly to cover almost anybody who is encompassed by any aspect of the criminal justice system. Like it is really something that, you should not believe that anything will be limited in that kind of careful way. It would ultimately apply to almost anyone. And it would be up to the discretion of the government to decide, who is going to have those things applied to them. So for me, I view Salerno and the court's acceptance so readily of this new constitutional understanding as a cautionary tale. At a minimum, I hope that one lesson people get from it is when you do something like that, don't expect it to be narrow. Instead expect just the opposite, which is it'll just expand over time.
Before we move on from Salerno, because as I warned you, I could talk about this or we could listen to you talk about it for a long time. I would like to read a sentence in that chapter that I intend to quote with appropriate attribution to you always, for as long as I continue to write, speak, and testify on this subject. It is my favorite line amongst many in your entire book. And you write, "The unthinkable, detaining someone without a trial, just based on an accusation, starts first to feel normal, then expected. And before you know it, people can't even remember a time when the world was different." Yet that different world was only a few decades back in existence, and our memories seem to be quite short in retrospect, does it not?
Yeah. Things change very fast. Norms change very quickly.
Let's shift to another case whose impact that I felt I really only fully understood after I read your book. I'd like the audience to know how the background of how the Supreme Court justified its opinion in Terry versus Ohio.
Oh, sure. Yeah. So Terry versus Ohio is, as you all probably remember, is the case that allows stop and frisk by the police on the basis of reasonable suspicion. And this is another one like the pretrial detention framework that has its roots in 1968. So this is a case that gets before the court in, it's decided in 1968. And so the court is considering whether or not to allow a stop and a frisk on the basis of these facts. So I'll tell you the facts, because when the court first hears the case, it's not planning on creating a new standard. It's not planning on creating something less than probable cause. The idea is, so it's 1968, and in addition to the unrest that I had mentioned, it's also worth noting that the presidential election, the Supreme Court is part of the presidential election of 1968 because both George Wallace and Richard Nixon are attacking the Supreme Court for not being sufficiently attentive to public safety and for issuing decisions that coddle criminals and allow people who have committed crimes to get off on technicalities. And the argument is based on the fact that the Supreme Court had decided MAP and Miranda cases. So the MAP case, MAP versus Ohio, is the exclusionary rule case that disallows the use of evidence that had been obtained through unconstitutional searches. And so in those cases, you have people who have, otherwise, you have people who have committed crimes, but it's hard to prove it because the evidence that you need is no longer allowed to be used. And so, the police are up in arms about that. There's editorials in papers around the country criticizing MAP. And Miranda, which is the case that gives people a warning that, they have a right to counsel and a right to remain silent, is similarly disfavored by a lot of the media and op-eds and whatnot, because the argument again is, that it's making it harder for the police to get guilty people convicted and therefore keep the streets safe. So in the 1968 election, even I knew that, but I was surprised by exactly how much the court was part of the election. People had lawn signs that said impeach Earl Warren. Like, you would have a sign for your candidate. It would say, impeach Earl Warren. And that would be like kind of your pro-Nixon sign or your pro-Wallace sign. So that's the environment when the Supreme Court is deliberating over Terry versus Ohio, right? Like they see lawns that say things like impeach Earl Warren, and they know there's editorials being written about the fact that the court is insensitive to public safety. And they get this case from Ohio where the claim that is made is that the police need to be able to stop people that are engaged in these, that looks like, crime is afoot. The police should be able to stop those people. And once they stop them, they should be able to frisk them for weapons to make sure that they're safe in the exchange. And the facts of Terry themselves are Officer McFadden, who had been a longtime officer on the force in Cleveland, mostly looking for pickpockets and shoplifters, see two men pacing up and down the sidewalk. It looks like the record indicates 3 times. And at one point, they're joined by a third man. And the 2 men who are originally together are Black, and the third man who comes up to join them briefly is white. And they pace up and back 3 times on a sidewalk, and they look in a window. That's it. That's the totality of what they have done to arouse the officer's suspicion. And the window that they're looking into is an airline ticket office. So it's not like, what you would really think of, like, what is suspicious about any of that? The argument really is based on the kind of norms or the kind of societal expectations at the time. What's really suspicious is having 2 Black men speak with this white man, because that's just not that common. And that's what really got the officer suspicious is the allegation. But Officer McFadden says he just thought something wasn't right, and so he stops. He ends up stopping the 2 Black men and frisking them for weapons. And the Supreme Court has to decide if that's okay. Now, if you think about what normally you would think of if you looked at the Fourth Amendment, is he would need probable cause that a crime had been or was about to be committed. But remember, all they did was walk up and back and look in a window. That's all he had. But when the Supreme Court votes, they vote that to uphold the police behavior. And I think, when you kind of look through their papers and how they're talking about the case, it just seems pretty clear that they are very focused on how the court is being perceived, the unrest of the time, that they're going to give the police a win here, as opposed to like another decision to get criticized. And so when the first draft of the opinion is written, it is written that there was probable cause, but none of the other justices, when they read the decision, can go along with it, because they basically read it and are like, oh, come on. We can't say that's probable cause. What was the probable cause? There is none. And that is when you get Justice Brennan coming up with this idea of, what if we create this new kind of standard that's like reasonable suspicion, or we make it a kind of different idea. There had been some lower court cases that had kind of cobbled together some kind of notion like this, but none of this is grounded in any kind of original meaning or, how we think about the Fourth Amendment. It's just this kind of pragmatic idea that let's just give them a lesser standard in this context. And I think, there's really great work by Sarah Seo, a historian, just showing this is bonkers from a history perspective. And if you had an originalist on the court at the time, I don't think we'd ever get this. I think you can only get this when you're talking about the late 1960s, before that really becomes a common way of deciding cases. And when I showed a draft of this chapter to a colleague of mine who was a law clerk that year on the court, what he said to me, which, I thought was interesting was that, what I don't understand in writing this chapter was just how crazy the world looked in that year. And he pointed out that you could look out the Supreme Court window and actually see DC on fire when Terry was being deliberated and decided. And, after oral argument, Martin Luther King is shot. 5 days before the decision is released, Bobby Kennedy is shot. So his point was just kind of like, in that environment, you're just gonna give the police a tool, basically, because things seem really kind of like you need to. And they basically did, when you look through the papers, it's very obvious they reasoned backward. Like, they had an outcome that they wanted. Let's let the police do this. And now how can we figure out how to write a decision that'll get us there? And and I think I'm not unsympathetic to the pragmatic argument. I'm really not. But if you are someone who is a believer in constitutional text and its original meaning, that you have to look at Terry as an outlier from that perspective. And and I think it's another one of those cases where the court was warned, by the way. There was briefing in the case by the by lots of organizations. Tony Amsterdam and others had pointed out, look, the relationship, one of the reasons that America is on fire is because the relationship between the police and communities of color is combustible. Like, they're being mistreated. This is the problem. And if you condone something like this, you're going to make all that worse. So it wasn't like the court didn't know that. It's in the briefs. You can read it, the argument that's there. But I think the court just had a really hard time thinking about deciding that case in any other way in the environment that they were in. So, ultimately it's an 8-1 decision, and only Justice Douglas dissents in a very poignant dissent about kind of tyranny and totalitarianism, but only he dissents. Later, Justice Marshall will say he made a mistake, and he shouldn't have gone along with it. But at the time, it's 8-1, and I think that's the product of a environment where, if you have public safety concerns are great enough, the idea is the Constitution can be bent a little bit to accommodate it. And after Terry, the reason that I think, I'm sure there's other policing cases that people might have in mind that they could think of to include in a book like this. But I think Terry is so important because not only because it is, this kind of weird textual innovation in terms of how you're going to read the Fourth Amendment and inconsistent with its history, but after this, what was just kind of an informal, some jurisdictions had, police just kind of did this as part of their walking on the beat. After Terry says this is okay, that is what's going to allow many American cities to adopt stop and frisk as a programmatic tactic, like something they're going to use really proactively. So here in New York, at its peak, more than 700,000 people were stopped and frisked. Now the numbers are like 10 to 12,000 after successful litigation that we could talk about if people are curious. But it wasn't because of the stop and frisk was held to be invalid as a practice. Just in New York, it was held invalid as being racially biased. But at its peak, if you're stopping 700,000 people, these are not friendly encounters. People talk about the trauma associated with the stops. I mentioned many of those cases in the book and what it does to people. And, when you're mass stopping people like that, even if only a small percentage of people ultimately get arrested as a result of it, which is true, it's a very low percentage, but because the number, the denominator is so big, it actually does end up being a sizable number of people for crimes that are, fairly low level, a lot of marijuana possession offenses, a lot of like resisting the officer, because the encounter, I think, itself is so fraught. That feeds into mass incarceration as well. You get a lot of detention and incarceration on that basis that you wouldn't get if you had to use the probable cause standard that the Constitution requires.
Well, and I will tell you that as I was reading the chapter, it occurred to me first ironic, and then something worse than that, and then you do get to it in the book itself, that I'm acknowledging how much time I individually or with my fellow judges spent in making sure that we were carefully reviewing law enforcement's search warrant applications. And making sure that as the officer sat across the table or otherwise, looking for that probable cause. On a regularly, but not often, kicking them back saying, no, it's not there. You need to give me some more information. It was a thoughtful, time-consuming process because that's the standard. And then as you point out with the numbers, the police are on the street searching people for reasons much, much less than what judges are having to justify in granting the warrants.
Yeah.
You do spend some time in the chapter talking about that, do you not?
Yes, no, absolutely. And I mean, the furtive movements, being in an area that seems like an area you shouldn't be in, those are all good enough. Those are all good enough to trigger the reasonable suspicion for a stop. So it doesn't take very much.
Well, with the
And,
time we have left, oh, sorry, go ahead.
no, you go ahead.
No, I just want to make sure that we have sufficient time to turn our attention to Bordenkircher. And I suspect that there's a good number of our audience here today that either practices or judges in California. So without embarrassing anyone, California really has no comprehensive penal code structure. It has at least three, I would argue, four separate sentencing schemes. Given a hypothetical set of individual circumstances, a room full of experienced felony judges often can't even reach a consensus on a lawful sentence. We have determinate sentencing. We have indeterminate sentencing, 3 strikes, sex offense sentencing, each loaded with their own constantly moving set of both conduct and status enhancements. So how did Bordenkircher get us to the point that we are now, and what has been the practical consequences for people like Clarence Allen and for tens of thousands of men and women like him?
Yeah, so for his case, for example, he has no record, introduces like 2 friends to each other because one of them has a brother who's a drug dealer, and finds himself, as a result of having made that introduction, being charged as part of a drug conspiracy. And everybody else in the conspiracy pleads guilty, and they get 8 years. And he decides he's going to exercise his constitutional right to a jury trial. He's going to go to trial. And the prosecutor basically says, if you're going to have the audacity to not plead guilty, he ends up with a life sentence as a result of going to trial. And I wish I could say that was unusual or an outlier, but it's not me, trying to kind of show people some, wildly outlier case. It's actually very common that, prosecutors will say in their negotiations with people, if you'll plead guilty, I will recommend this sentence. It'll be this sentence. But, if you go to trial, if you're going to make me have to go through a trial, then, all bets are off. And the sentence you're going to face, is potentially a mandatory one if you're convicted. And those were the facts in Bordenkircher itself. So in that case, you had an individual who, Mr. Hayes, had, forged a check for $88.30. And the prosecutor said, look, I'm filing the charges against you. It had a 2 to 10 year sentencing range. And the prosecutor said, look, I'm going to offer you 5 years if you plead guilty. And Bordenkircher, or Hayes, excuse me, didn't take the deal, said, I want to go to trial. I want to exercise my jury trial right. And the prosecutor said, again, it's on the record where the prosecutor says, if I have to go through the inconvenience, of a trial, then I'm going to supersede the indictment and I'm going to add charges where you're a habitual offender. And under the law, you would get, under the state habitual offender law, he would get a life sentence if convicted because, he had a couple other offenses in his background. So, plea deal, 5 years. If you exercise your jury trial right, life sentence. I think that anybody who would look at that, who knows anything about the constitutional doctrine of unconstitutional conditions, would say, how could that possibly be okay? You know, how could we allow the jury trial right to have that kind of burden placed on it? That if you're going to exercise your jury trial right, you're going to get a life sentence when the prosecutor would have otherwise been okay with 5 years. But ultimately, when the Supreme Court gets the case, they decide 5-4. Yeah, it's okay. You know, they go along with it, and the reason they go along with it is basically they say it's the give and take of plea bargaining. You know, I think they believe that if you don't allow there to be bargaining, that the system just would be crushed under the weight of all the cases, that you have to allow it. You know, there's a speech given by Chief Justice Berger a few years before that case, before Bordenkircher is decided, and it's one of his like State of the Judiciary speeches that the Chief Justice, you know, gives his report. And back then in the early 70s, he gave the speech to the ABA, and it was actually televised. It was televised on the three, remember there were just the three networks and the UHF channels. I remember that. And so you had to watch, if you were going to watch on the networks, your only choice was watching Chief Justice Berger give his State of the Judiciary speech. And when he gave this speech, he had said, you know, we have to have people pleading guilty, because if we even went from a rate of 70% to 80% of cases, you know, if we went from 80% to 70% of the cases where we didn't have pleas, we'd have to double the courthouses and the judges, and the system would just, you know, it would collapse. So the justices themselves are really of the view that you need to have this for the system to function. And so I think even when they're faced with like a really coercive framework like the one that they had before them in Bordenkircher, they go along with it, you know, and once they do, you know, again, after the case, you had it before, so I'm not saying there wasn't plea bargaining, there was, but it was similar to what I was saying with Salerno, which is, yeah, you had judges who were detaining people because they thought they were dangerousness, but nobody thought it was okay. Like they were kind of just doing it and hoping that it could just happen without it being accepted as normalized or condoned by the Constitution. After the Supreme Court makes clear in Bordenkircher that you could even have this kind of 5-year versus life thing, I think prosecutors after that feel completely free to just make all kinds of coercive threats to people about what will happen if they exercise their jury trial right. And so it's not surprising that after the case is decided, you know, we have plea rates that go up, you know, to 95%, 98% of all convictions are the result of people pleading guilty. And, you know, when you think about that, why are these people pleading guilty? Well, they're pleading guilty because if they go to trial, they're facing sentences orders of magnitude greater. And who's going to take that risk? Even if you're innocent, you're not going to take that risk. Because you don't know that the jury is ultimately going to believe you, and your exposure to so much longer prison time is just too great. And so plea bargaining, you know, is the engine of mass incarceration, truly, because you just have to have mass case processing quickly to get this many people incarcerated in America. And so you know, if I had to pick one case that I think is like the centerpiece of what allows this to happen, it is allowing coercive plea bargaining.
I think you and I have traded anecdotal stories, either from personal experience from my case, or things that you have become aware of or I've become aware of. And the disparity between the offer and what ultimately happens, not only in the sentence, but what the prosecutor argues at the time of sentencing, is breathtaking. I sent you one. I believe the defendant's name was Shabri Dillon. I'll spare everybody my own personal experiences, but these are cases where the charged defendant is offered a sentence of between 1 and 5 years, and she turns it down. And she says, I want to exercise my constitutional right to a jury trial. She goes to trial and is convicted of some, or perhaps all of the charges. Then at the time of sentencing, the very prosecutor who offered that deal asks for in excess of 80 years in state prison. And I do know of individual judges who personally won't make sure that the defendant knows that there will not be a trial penalty imposed. In other words, when we had a direct calendaring system, defendants would come in front of me. They'd want to know what would be the sentence? And if I was in a position where I felt I really did know most of the facts or there was no dispute, I would tell the defendant, if you decide with the advice of your lawyer to waive your constitutional right to trial, this is going to be your sentence. But I'm also going to tell you that unless I hear something at trial that's different than I know now, and you get convicted, that'll still be your sentence. Now, some decided they didn't want to go through the process and they pled. But are you aware of any jurisdiction that puts even a limit on that? For example, if an offer is made for 5 years, if the person exercises their right to a trial, a sentence can't be imposed more than X number of years on top of that. Are you aware of any jurisdiction that has that protection?
I'm not. I mean, it could, if someone knows, I would love to hear about it, but I'm not aware of that. I mean, I'm definitely aware of people who have advocated for that, who have asked there to be some kind of a cap, a ratio, some kind of way of thinking about it. And I think that's a good idea. But I am not aware of that.
Okay. Well, we want to allow sufficient time for any questions that the audience may have. However, I do want to read a bit of your conclusion in your book, and then I'm going to take a little privilege and ask the first question, because I warned you about this the last time we talked. Your quote is a heavy one. The Constitution is no better than the people who defend it, and the Supreme Court has shown it is not up to the task of protecting constitutional rights in the face of government claims that they must yield in the interest of public safety. The court should have been on the front lines defending the Constitution against the relentless attempts at excessive governmental powers and severity. Its failure to fulfill its central constitutional role in this context is both tragic and indefensible. By refusing to uphold key constitutional protections, the court paved the way for the mass incarceration we see today. You include a quote from Justice Ginsburg. I'm hopeful that if the court has a blind spot today, its eyes will be open tomorrow. Yet the circumstances in which we find ourselves as we speak, how do we possibly wend our way home or forward from here?
Yeah, I wish I could say I was more optimistic. But I guess I would say that I think sometimes you have to take a long view. And I think Korematsu is an example of that. I think you have it accepted and decided when it is, and then, many decades later, it is seen for the horrible decision that we all now recognize it to be. And my hope is that someday these cases will have a similar trajectory, but I think it starts by showing how much of a departure they were from settled understandings of the Constitution when they were decided. And then, from there, just educating people that we lived in a different time before and we were okay. We were safe. We were able to have a different understanding of the Constitution and still make it through. And I guess, the optimism would be that if the court can be educated to understand that it wasn't always like this, you could decide things differently, that it'll recognize that decisions can be overruled, they can be limited, we can learn from the past, we can learn from empirical information about, even if we think something's necessary for public safety, if we do studies to show that it's not necessary, maybe then the next time the issue comes up, the case is decided differently. So, I try to remain, hopeful but not naive, and basically just think that it's, I don't think things will change tomorrow. But I do think the first step is just unearthing some of this so that people understand this was a big change. And I think, even if it's just, one judge, two judges, a justice, someday, somebody, anybody who finds some of this to be enlightening, that, over time that can build the case for something bigger. And I think it's also important, not just for the bench, but for the public to understand that too. I think it's easy to make decisions when you're afraid, that it seems like what you're doing is worth it, that it's worth it. But I think, the thing that makes our Constitution special, and that we all have to really understand and share, is that it's a document for the long haul. And it's really important to guard these very sacred liberty defenses, so that even when there's a temptation for them to yield, we understand their value. And I guess if I'm going to take one hopeful thing from the current environment, I have to admit I was pleasantly surprised to see a poll on the kind of the notion of due process for people being deported, that a majority, well over a majority of the public was in favor of due process. And if I had to have taken a guess, I would have thought that, due process wouldn't poll well. Maybe people might understand its value, but the idea that you could actually ask people what they think about it and they see the value suggests to me that, maybe civics education isn't as bad as I thought. And maybe people do have an understanding of the value of courts and process in terms of protecting all of us. So, I'm going to try to remain hopeful, at least hopeful enough to kind of keep up the argument, because I think, if you give up, then it's obviously it's over for everyone. So I think it's important to keep trying to let people realize it doesn't have to be a particular way, and that change is possible.
Before deferring to Denise with the questions that the audience may have for you, Professor Barkow, I have a last question. It's one that I posed to you, and you definitely deferred, but you promised that you'd answer even before this audience that we have. So, is there such a thing as a Supreme Court Justice's counterclerk? And now, after reading your post-clerking scholarship, including 2 published books that are meticulously researched, that honestly focuses on and expose the horror of mass incarceration, is that the role that you serve for Justice Scalia?
So there is a counter clerk in the sense that Justice Scalia did make a point of trying to hire, not every year, I will say, but some years he liked hiring people who did not share his political outlook. He thought it was valuable for his own decision-making process to have people who didn't necessarily see the world the same way that he did, because he thought it would make him a better judge. So that part is true. And I'm just not sure I was a counter clerk because, and I will tell you, he knew I was a Democrat, and therefore did not share his political ideology. But I am someone who is, believes in the methodology of textualism and looking at original meaning and, being consistent with precedent. I'm a very small c conservative when it comes to judicial decision making, and I always have been. And so, in that respect, and he knew that when he hired me too. So it's unclear whether he thought of me in that way, because I guess is a somewhat unusual pairing in a person. And so as a result, I don't really know. And that is the honest answer to that part of the question. But I did love working for him. I thought it was a great experience.
I'm sure it was. Denise, I believe that you've indicated there are some questions that the audience would like to pose to Professor Barkow.
Please. First, I got so many DM chats about how wonderful the conversation was. So thank you for that. One wonderful questioner who said, I'm not a lawyer or an academic, and then poses a question that lawyers and academics are dealing with all the time. Harkening back to the end of the conversation, how do we reconcile the constitutional right to due process and the impact and consequences of the 1984 Bail Reform Act? And this commenter notes that right to due process is especially relevant today for obvious reasons.
Yeah, so it's a great question. The way the Supreme Court reconciled it was to say that it was consistent with due process. I mean, you do get an individualist determination as to whether or not you're going to be detained pre-trial under the Bail Reform Act. It's just that these presumptions that operate when you're charged with certain offenses. There's a great study that I would recommend to people who are interested in this by the University of Chicago, has a clinic that went around and looked at how federal bail decisions were made around the country. And they found it was pretty much a rubber stamp. The government asks for detention, judge gives detention. And so I think if you looked at that, you might not think due process is robust, but you are still before a judge. You still do have an opportunity to make the claim that you should be released. And so there is a notice of this. There's an opportunity to be heard. And I think the more scary discussion right now in terms of the threat to due process would be the notion that you wouldn't even have an opportunity to go before a judge at all, that you wouldn't have that neutral decision maker deciding that the government's claims have any support at all in the record. That is the ultimate threat to due process, that it's just the government on its own making the decision. They are your judge. They are deciding, yep, you are deportable, and off you go, without ever having appeared before a judge. So, it's certainly a way graver threat to any notion that we think of as due process. But you can make the argument that Salerno itself was not consistent with the notion of the presumption of innocence that's part of the due process understanding. And that's what I spend some time on in the book, is that kind of idea was pretty hardwired into our constitutional understandings. And that's the one that slips away, but you do still have an opportunity to go before a judge.
All of these questions could be their own law review articles. One questioner says, I think callousness plays a role in the cruelty of the current trends in the executive and perhaps the dangerousness findings you discuss. How do we increase trial judges' empathy? And this might be for both of you, and it might be our final question. How do we increase trial judges' empathy and perhaps identification with defendants as human beings who can benefit from remaining connected with the community?
I feel like I should defer to the judge on this one from professional experience.
I'm going to bounce it back only because I think our audience tuned in to hear from you and not to me today.
All right. Well, I'll hear from you later, I guess, on this, because I would like to know what you think. But I do think that this goes back to where I earlier had made the argument that I think professional and life experience are really valuable here. I think it's really important for anyone who sits on the bench or is part of making decisions about people in terms of punishment. I think all those people should visit jails and prisons. I think it's important to see the spaces that you're sending somebody to. I think it really brings home exactly the weight of the decision that you're making. I have visited jails and prisons. I think it becomes really clear when you see them. You feel the weight of the decision, I think, as soon as you know that. I think it's also very helpful, for people to truly listen to what people are saying the hardship is of, pretrial detention. There was this exercise that a federal U.S. attorney did in Mobile, Alabama, that I heard about several years ago during the Obama administration, that I thought was a really great way to address this, which is they ran a simulation for judges where the judge had to pretend they were a person who was trying to navigate all the requirements, to stay out of the system, that they had to get certain papers, they had to show up to certain things. And so they had to get like their paper stamped, and there were lines and there were things in the simulation that made it show how difficult it was to kind of comply with everything. And, he had said even that simulation made it brought home for people exactly, that it's not just that someone's like flouting what you're ordering them to do, but sometimes things are just really hard. It's hard to get childcare. It's hard to make the bus route. It's hard to do certain things. And I think, the more people have that direct contact and understanding of what people are going through, the better. And I do think people with a certain professional experiences, that kind of comes with the territory. I think if you have been a defense lawyer, you've had individual clients, not just working on the government side, I think that comes through. I think you almost by definition have had that. I don't think it's necessary. I think there's other ways that you can get that same kind of experience, but I do think those kinds of interactions with individuals, so that you understand, if you're just looking at the government side of things, I think you can miss the humanity and that kind of personal difficulty that people have as they try to navigate things.
I think we are close. Oh, go ahead.
I was going to say the same thing. We have some wonderful questions because what you've done is provoke wonderful thoughts. So thank you. I will say Berkeley Judicial does have some programs about empathy. Many judicial education organizations do exactly what you say, bring judges to prisons and jails to see what people will encounter. But I do want to give the judge the opportunity to close up the program. I'm so grateful to both of you for this program.
Well, thank you, Denise. And I just would like to once again thank Professor Barkow this afternoon. She really is a star in the firmament of legal academia. Her current and most recent book is Justice Abandoned: How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration. I could not endorse it any more strongly, but I would also suggest that if you find it anywhere near as interesting as I did, you want to read her first book, which was published just a few years ago, Prisoners of Politics: Breaking the Cycle of Mass Incarceration. Professor Rachel Barkow, thank you so very much for today, and thank you for all the work that you do on behalf of those who toil in the area of criminal justice.
Oh, the pleasure was all mine. Thank you so much. I really appreciate everybody's time. Thank you so much.